How do we challenge statutes and lobby the judiciary? Can you actually lobby the judiciary? The judiciary sometimes is the forgotten branch of state government when it comes to the lawmaking process. But hopefully, we know and understand that the courts in this state can and do play a critical role because the judges, of course, interpret the law and their decisions may comport with the interpretation that was intended by the legislature, or a court decision may result in something quite different, in fact, potentially opposite of what the legislature intended. The courts, of course, can also uphold a statute or they can strike one down. They can also narrow the application of the language if they find part of it invalid or unconstitutional. Every year, there are bills considered by the California legislature because of a court decision. And those types of bills may clarify existing law. They may try, the legislature that is, to overturn a court decision that they disagree with, or the legislature may amend a law to be consistent with the court's interpretation of it. Members of the state and federal judicial branches, of course, play a role in the California lawmaking process as a part of our government system of checks and balances. And obviously, the judiciary represents the third branch of government and is co-equal to the legislative and executive branches. When California statutes or regulations are challenged in court, then the state or federal court that issues a decision establishes a policy for the state. And California statutes and regulations, of course, can be challenged on federal or state constitutional grounds where appropriate. As a result, both the state and the federal courts may end up playing a key role in the state's lawmaking process when those state or federal courts issue written decisions based upon a challenge to a new or existing statute or regulation. The other major way in which the courts make state public policy is through statutory interpretation. In this regard, there's a statute, a group of statutes, or even a series of them that have been enacted by the legislature that have some ambiguity. They might be unclear or even silent in some aspect in that area of law. And so the court sometimes is basically asked to fill in the gap, to discern the intent of the legislature and give meaning to the law where it may be unclear or ambiguous. Thus, to invoke this approach, the party challenging the statute is going to need a statute or statutory scheme which is unclear or silent on some sort of public policy issue, and a cause of action and standing to sue so that they can properly bring a lawsuit in state or federal court. And this formal process essentially results in formal lobbying of the judicial branch. In addition, pending litigation can preclude consideration of legislation out of legislators' concern that a bill could impact a current legal case. And often state legislators are unwilling to interfere when there's pending litigation to resolve a matter. In other words, if a lawsuit is currently pending in the state or federal courts, often the legislative branch of government declines to act until the judicial branch has concluded that legal process. Another aspect to consider is that an individual or group that might have been successful in the legislative process and maybe even in the regulatory process, but then they could be called upon to defend their legislative and or regulatory victory in the courts. Consider that your opposition in the legislative and or regulatory arenas may challenge those victories in the legislative or executive branches in state or federal court, which could result in a reduction of your or a weakening of your victory that you had previously achieved. In fact, you could lose an entire statute or an entire regulation with an adverse court decision. So, as strange as it may sound, there is actually lobbying of the judicial branch of government because interest groups work to influence the courts in a number of ways, the most common of which is filing an amicus brief or a friend of the court brief, in which these interest groups present either legal briefs in support or in opposition in a case. And some interest groups file lawsuits against the government challenging their interpretation or enforcement or application of statutes or regulations. And so lobbying the judiciary ends up sort of in the forgotten or unknown area of lobbying, in fact. Now, this doesn't mean ex parte communications with judges, which are obviously prohibited. It means filing an amicus curiae or friend of the court brief with the court, which is the formal process of lobbying the judicial branch of government. The state and the federal judiciaries can, again, significantly impact laws and regulations, sometimes modifying or even undoing what the legislative or executive branches have done. Because of this, lobbyists and interest groups should actively monitor the formal decisions that are issued by the appellate courts in the state of California, even keeping an eye on some of the trial courts, because these decisions could impact a statute you worked on or a regulation that you worked on, or just may give rise to a need to change the law in order to address an appellate court decision in the state.